A very good afternoon to all the panelists and the audience watching the event. Today, we are here to release 2 books on arbitration. A very good afternoon to all the panelists and the audience watching. The first book is Arbitration and Conciliation, a commentary by Saurabh Bindal and Prabhat. This book is a first edition. It was a labor of love for many months and went through multiple rounds of refinement. When the manuscript first came to us, it was reviewed by Mr. Sudeep Malik. With his inputs, the manuscript was made even more comprehensive to include all the latest judgments of the Supreme Court and the High Courts. Later, it was copy-edited, typeset, and proofread. Every single citation and extract in the book was cross-checked to make it as error-free as possible. Both Mr. Bindal and Mr. Prabhat have done a wonderful job of bringing out a book which is both exhaustive and updated with the latest trends in arbitration law. The second book is Dr. Aftar Singh's Law of Arbitration and Conciliation, revised by Mr. Saurabh Bindal. Dr. Aftar Singh's name needs no introduction. They say an author is truly a bestseller when his books are available on the roadside and in tiny bookstores. I have grown up reading Dr. Singh's books, and it was a pleasure to see his legacy continue even after his passing away in the form of the 12th edition of Dr. Aftar Singh's Arbitration and Conciliation book. Author Saurabh Bindal has ensured to update it with the latest amendments in law as well as all the important case laws. The book release will be followed by a panel discussion on amendments in the Arbitration Act which transformed India. Now, I would like to welcome all the panelists. First, I would like to welcome Justice A.K. Sikri. Justice Sikri is currently an international judge at the Singapore International Commercial Court. He started his practice at the Delhi High Court and has handled all types of cases with specialization in arbitration, commercial, labor, and constitutional matters. He was later designated as the senior advocate by the Delhi High Court. He went on to serve as a judge of the Delhi High Court and the Punjab and Haryana High Court. He was later appointed to be the judge of the Supreme Court of India. Currently, he's also engaged in doing opinion work, mediation, as well as arbitration, both domestic and international. Other than serving as the international judge of the Singapore International Commercial Court, he also holds several other important positions. A very warm welcome to you, sir. Next, I would like to welcome Mr. Stephen Baier Lim. Mr. Lim is an arbitrator and barrister. He has several appointments as the presiding, sole, co-arbitrator and emergency arbitrator seated in Singapore, England, USA, India, and many other countries. He is also instructed as the lead counsel in arbitrations and is a member of the Singapore and English bars. Mr. Lim has extensive experience with several well-recognized international arbitration institution rules and ad hoc cases involving Asia-Pacific jurisdictions and further afield, and is also on the panel of several international arbitration institutions. Mr. Lim is recommended in legal directories as a highly respected figure across the gamut of APAC-related commercial disputes and an excellent counsel with excellent understanding of law and great commercial insight. We are very pleased to have you, Mr. Lim. Next, I would like to welcome Mr. Stephen Pinzo. Mr. Pinzo is a partner in Wilmer Cutler, Pickering, Hale and Dorr LLP. His practice focuses on international dispute resolution, and he also serves as an arbitrator. He has particular experience with energy, financial services, shareholder, joint venture, M&A, and manufacturing issues. He has advised clients regarding disputes under the rules of the most well-recognized international arbitration institutions governed by the laws of jurisdiction in Europe, Asia, Africa, and the US. His pro bono work has included assisting a Central European government to draft new arbitration legislation and has been part of a team that won a landmark decision in the first freedom of expression case in the African Court on Human and People's Rights in Issa Loho Konate versus Burkina Faso. Thank you for agreeing to be a panelist, Mr. Pinzo. Next, I would like to welcome Mr. Saurabh Bindal. Mr. Bindal is an advocate practicing law at the Supreme Court of India and the Delhi High Court. He holds a degree in engineering and law. He was called to the bar in 2012 and has worked with several reputed law firms in India. He has focused his practice on litigation and dispute resolution, and he has appeared in different forums and handles high-stake litigations and arbitrations. Welcome, Mr. Bindal, and thank you for trusting EBC to be your publisher. Last but not the least, I would like to welcome Mr. R.V. Prabhat. Mr. Prabhat is a co-author of the book Arbitration and Conciliation, a Commentary, which is to be released today. He is an advocate practicing law, who's practicing law at the Supreme Court of India and the Delhi High Court. He also holds a degree in engineering and law and is a qualified company secretary. His interest areas include commercial and construction arbitration, insolvency law, company law, and the Constitution. Welcome, Mr. Prabhat. Next, I would like to call upon Mr. Sumit Malik, Director, Eastern Book Company, to say a few words on the occasion.
Justice A.K. Sikri, Mr. Stephen Lim, Mr. Stephen Pinzo, Mr. Saurabh Bindal, Mr. R.V. Prabhat, lawyers, judges, arbitrators, students, and gentle people. It is my privilege and pleasure to welcome all of you to this event, where we'll be celebrating not one, but two books. The first one is an original work, a section-by-section commentary on the Indian Arbitration and Conciliation Act, written by Saurabh and Prabhat. And the second one is a revised edition of a classic, Dr. Aftar Singh's textbook on arbitration and conciliation law. I'm grateful to Justice Sikri, our chief guest, and our panelists, Stephen Pinzo and Stephen Lim, for taking the time out to participate in this event. EBC's association with Dr. Aftar Singh began nearly 50 years ago with the publication of his book on company law. That book became the foremost book on company law to study from, whether at law schools, business schools, or even commerce courses. EBC then went on to publish many more of his books on contract and specific relief, sale of goods, mercantile law, now called business law, negotiable instruments, etc. Many of them were revised multiple times and ran into many editions during his lifetime. After his passing away, we have been taking up the revision of his books, and already new editions of many of his books have been published. EBC's association with Saurabh is a little more recent. EBC published his co-authored book on intellectual property in 2015. These are his third and fourth book, respectively, published by EBC. Our association with Prabhat begins with this book. Justice Sikri and I have had some interesting conversations around him, writing on some unexplored areas of law and on some perspectives of law hereto unexplored. I am very excited about them, and we hope that those manuscripts will fructify soon. So, in this new world of technology and artificial intelligence, which allows for instant self-publishing, publishing on blogs, etc., the question is, how do we at EBC see ourselves? What is the role of a publisher? In today's context, I can say that we see ourselves as the trustees of the legacies of authors. Even though Dr. Aftar Singh may not be living amongst us, yet by getting his books revised regularly, we hope to perpetuate his legacy. Saurabh and Prabhat are young authors, and we hope to see not only many more of editions of this book, but books on more subjects. Already, Saurabh is working on another very interesting topic. As we at EBC enter the 80th year since our incorporation, what we have learned is to understand that the legal profession requires and what our role can be in fulfilling that requirement. We believe that our role is to bridge the gap between legal information and knowledge and those who consume that legal information and knowledge. As a third generation member of this publishing house, I have been blessed to have been shown the way by my elders. My granduncle and grandfather had very humble beginnings, delivering books on bicycles to lawyers, including the great Mr. Ambedkar, when they started off as booksellers in 1942. But even then, the mission was clear: provide a service which will assist the practitioner in her work. The mission continued with the same spirit when EBC started publishing books for lawyers and for students in 1947. The books we produce today must necessarily be of very high quality and assist the user in their quest for knowledge. To be effective in our role, it is important that the materials or content that we produce is authentic, accurate, and reliable. Also, we've continued to innovate over the years to keep ourselves relevant. In 1969, when Mr. Suren Malik graduated from the Delhi University, having studied by the newly introduced case method, he realized that there was a need for faster reporting of Supreme Court judgments. Thus came about the innovation of Supreme Court cases. As you are all well aware, that there can be no second edition of a law report, and it must be got right the first time. Prompt, accurate, and complete has been our philosophy, which we have adhered to since then, and we understand and recognize our responsibility that the honorable judges in the bar rely on Supreme Court cases. As soon as publishing shifted to desktop publishing, we at EBC adopted it, and shifting our printing from hand-composed type to software-designed typeset, and now to digital printing, the latest innovation in the field. Print on demand has gotten to the publishing industry before laser printers printed aircraft parts and human hearts. EBC was amongst the first Indian publishers to introduce a legal research database on CD-ROM in 1996, which was then less than 650 megabytes in size. And now on the SCC Online Web Edition has grown to over 20 terabytes of data, over 4.6 million documents covering 300 plus jurisdictions around the world. Even though we believe that the printed book is not going away, yet for the tech-savvy, EBC's EBC Reader platform is ready and already has over 400 ebooks on it, and we add new and newer titles every day. The SCC Online blog, on which we report the happenings in courts, law schools, and the like, has now over 1 million views and over 500,000 visitors every month. Constantly innovating, EBC's newest services, EBC Learning, an e-learning platform, and Mercury, a judgment tracking software, are already gaining loyal users. We're also fortunate to have, as part of the EBC family, a dedicated team of legal editors, software engineers, DTP staff, proofreaders, sales and marketing staff, and managers who are, if not sometimes more, invested in ensuring that what we produce from the House of EBC is of high quality, authentic, accurate, and reliable. It has been a wonderful experience working with Saurabh and Prabhat on this book. And as I said, Saurabh's already working on another title, and we hope to see the light of things very soon. Thank you.
Thank you, Mr. Malik. Now I would like to call upon Justice Sikri to release the book. I would also like to request all the panelists to hold both the books up on their hands. This. I'll just take a screenshot. Thank you, everyone. Now I would like to call upon Justice Sikri, our chief guest for the event, to say a few words.
Thank you, Nilofer, and good morning, or good evening, or good afternoon, depending upon the jurisdiction or the places from where many persons who have been attending this function online. And my warm welcome as well as good wishes to Stephen Lim. Now I can claim my old friend, because we have been friends for more than 3 years now. And I still remember my first international arbitration, where Stephen had, along with others, nominated me or appointed me as the presiding arbitrator or the chair. And after some time, I appointed him in some other case. Interestingly, both the cases ended up in settlement and the parties settled. So I would say that it's a good omen. And in any case, our friendship is thriving. And to Stephen Finizio as well. Of course, although we are meeting for the first time, but I can, as his credentials, which were spoken about and read by Nilofer clearly demonstrates that he is a person who is well recognized in the field of arbitration. And of course, the two heroes of today's function, Saurabh Bindal and Prabhat, who have written, who are the co-authors of this book, Arbitration and Conciliation, and Saurabh, who has revised this book, Arbitration and Conciliation, authored by Professor Aftar Singh. I am amazed at the speed at which Saurabh is really churning out this literature or the writing these books. As was told to us by Sumit, that first book he had written and his association with EBC started in the year 2015. Must be a very, very young advocate at that time, 7 years ago. So writing first book, and now these are third and fourth books of Saurabh. I really, why I say so that I am amazed. I know that, and Sumit also knows, I've been thinking for last maybe now 10 years to write a book. First, because of my busy schedule as a judge of the Indian Supreme Court, and as you know, that as far as judge of Indian Supreme Court is concerned, he is the busiest judge in the world, the kind of work which he or she has to do. And therefore, even when I had some projects in mind and I had done some work, but I could not bring that to fruition. Even after my retirement, I had thought that I will start doing it immediately, but I should thank God that I feel that kind of work I am getting as arbitrator, I feel that I have not retired, and therefore I have not been able to. But having said that, and the two lawyers I know who are very busy lawyers, Prabhat has been appearing before me in some arbitration matters as well. And in spite thereof, they have been able to take out time and to write this. Normally, lawyers don't get time, or even when they get time, they may not have that kind of neck to write books. But those who are busy and are able to do, take out time to write these books. This is really, that is why I use the word. I am amazed at your the work which you have done. And insofar as your first book is concerned, Arbitration and Conciliation, your commentary, I would only say that there's so many books in India on arbitration, no doubt. Why another book? But this stands out in some ways. And I don't have to say much on that, because the person who has written the foreword, that itself is a certification. If Justice Nariman agreed to write a foreword to your book, that means he must be convinced that this book is of very high quality, and you really deserve that commendation and really deserve for him to pen down his thoughts in the form of foreword to this book. And not only it is Justice Nariman, but the stalwarts of legal profession like Abhishek Manu giving special message, then special message by Gary Bond, special message by I think Arvind Dattar, Nish Sethi, then our Stephen Lim has given special message, Mr. Tankha, sorry, not Dattar. So all these persons contributing, and these are sort of encouragements. And I feel that even when there are many books, because we can't, we don't have much time to say about the book, but I would only say that even the foreword, of course, it is only 1.5 page foreword written by Justice Nariman, but it captures the essence of what the book is about. And as he has rightly mentioned, that the authors begin with the history of arbitration in India and trace its checkered path, including the latest amendment of 2021 to the Arbitration and Conciliation Act. So in that respect, if somebody wants to read about Indian law on arbitration, this is the most updated book. There's no doubt about it. And the manner in which as far as history is also concerned, how our from 1940 Act, which was of course had to be repealed and was brought in on the basis of ancestral model. It's not only India. Many countries who had enacted the law on the basis of ancestral model, almost same kind of law. But in India, in the beginning, at least from say 2002 or 3 onward, how we went into that rough patch. And because of some judgments given by the Supreme Court at that time, and it was treated as if the spirit of the Act, Arbitration and Conciliation Act 1996, is not captured in those judgments, and we are going backward and all. But over a period of time, this has changed, and we have to have, and this is the message which has to be sent to the international community, that the arbitration culture or arbitration environment is user friendly, for which so many things are needed. It's not only law, but the enforcement of that law as well by the courts, and more importantly, what is the spirit behind this act, that not only party autonomy has to be respected, but at the same time it has to be a quick and a speedy method of dispute resolution, and not and cost effective also. So whether we have been able to achieve that or not, all that is captured in this book. When it comes to Aftar Singh's, Dr. Aftar Singh's updation of that book, and I know Nilofer said that, look, we have been reading this books even as students. And let me tell you, even as students, I have read that book way back in 1970s, early 70s, when I was a student. He was, of course, teacher, was known as outstanding teacher in the country, no doubt about it. And the many books which he wrote, and Sumit has mentioned all those books. I know for students, all these books were so famous and so popular that across the country, these books were in circulation. And I was, this task was given to me insofar as this book is concerned, and I have written the foreword to this book. So I feel privileged to do this. And at the end, I must say a compliment EBC and Sumit Malik to give that kind of, because let me say in the beginning that EBC has earned name in this country. This is, I think, in law they are today rated as, if I'm not mistaken, and even if it is so, it is my judgment at least, that they are the best as far as law publication in India is concerned, whether it is publication of books or Supreme Court cases, SCC journal, which is the only journal apart from their SCR official journal, which is recognized by the Supreme Court, and it is I think the only journal which is cited before the Supreme Court day in and day out. And I may not say much about them, but only what I'm saying is why I comment that the way they have encouraged these young authors in recognizing their work, because if the work is published by EBC, quality is assured. That also is a certificate that this work is of quality. Otherwise, I know Mr. Malik will not take up that project and will not publish. So therefore, these are the reasons which I would say to the all the audience who are sitting here. As far as Aftar Singh's book is concerned, again, it would be as it had been up to now, it would be popular among students. And insofar as Arbitration and Conciliation commentary second book is concerned, I think it would be consulting. The way it is written in such a easy and lucid manner, it would be an important tool for all the practitioners, for judges and students alike. Thank you very
much. Thanks a lot, Justice Sikri, for your kind words. Next, I would like to call upon the authors To say a few words, I would like Mr. Bindal to begin and Mr. Prabhat can follow.
Well, thank you, Nilofer, for giving me the stage. Before I tell you about the books, I would certainly like to place on record my sincere gratitude towards Justice A.K. Sikri for writing a foreword for one of my books and for being here for the release as the chief guest. It's an honor to have you here, sir. I'll also not do justice if I fail to acknowledge Mr. Lim and Mr. Pinzo for being part of this book launch. Thank you for readily accepting the invitation. My gratitude would also go to Mr. Malik and Eastern Book Company. Mr. Malik has always been a mentor to me in all my projects. And the thing with EBC is, as Justice A.K. Sikri was pointing out, that they handhold you from the very go. So once you submit the manuscript with them, they'll make sure that the manuscript is thoroughly reviewed and the outcome is as good as it can be. Mr. Malik's team, particularly Nilofer, for taking care of the script and making sure that it comes to a publishable form, also needs acknowledgement for this work. She has always been available for early morning discussions on the script of my books. And when I say early morning, some people who have logged in this event would know what early morning means for me, and Nilofer would definitely know what early morning means for me. So thank you for being here and being part of this event. I would also like to thank Ms. Chitali Bose. She is the copy editor for my books, and Mr. Ranjan Sharma, who is the DTP for the books. Last but not the least, I would also like to thank all the audience who are present here for the launch of my two books. And these two books are very close to my heart because the first one, which Justice Sikri was talking about, is a commentary, and it covers case-by-case analysis of how arbitration law has transformed over the years. And it's written in such a lucid and crisp manner that I certainly believe that as a practitioner of law or as a student who would like to understand what arbitration is, that book is going to be much helpful. As Stephen is present here, and he has actually written one of these special messages for my book, which is the commentary, I would like to read some excerpts from what he wrote for that book. And he particularly wrote, and I quote, that I commend the authors for their work in taking on the task of tracing and elucidating the Indian experience with the model law. This book will serve international arbitration practitioners outside India just as well as it does Indian readers. It will explain concepts to international readers, which, though apparently familiar with model law roots, have taken on distinctly Indian flavors and nuances. International readers who want to understand how the model law is applied in India will do well to turn to this book. So Mr. Lim, who is one of the panelists, has given this comment on my book, and I'm certainly honored to have such a comment. And I believe that he would have reviewed it. And if any legal action lies against any discrepancy in the book, that Mr. Lim is to be sued for it. Now I would, when I'll go to this book and I'll talk about how we conceptualize it. So when Prabhat and I were thinking about this book, we wanted the readers to actually get a flavor of arbitration without going to lengthy commentaries. A short and concise commentary for that reason, we thought was in need of the hour. And I believe the book, which I heard it's now called the Blue Book, will be the must sought after book in the near future. Coming to the next book, I won't take much time. Coming to the next book, which is Aftar Singh Law on Arbitration and Conciliation. When Mr. Malik approached me to revise this book, I took this as an opportunity because, as Justice Sikri has rightly pointed out in the book, once a law student, you always remain a law student. So if you have not read about Dr. Aftar Singh, you cannot claim to be a law student in India. So when this opportunity came to me, I thought that this is the best moment to capture it, and I got into it. I would like to read one of the excerpts what Justice Sikri has wrote for the book. To be very frank, Justice Sikri said that he has written a foreword for the book. But if you read Justice Sikri's foreword, you will get the essence of the book. It is more of an introduction. And I'll read one of the excerpts from what Justice Sikri wrote. Justice Sikri writes that it is commendable that the author does not discuss arbitration in exclusion of the judicial practices. The book discusses the difference between arbitration and litigation and goes on to noting the points of judicial interventions and reviews in the practice of arbitration. It is a matter widely known and understood that even though arbitration as an alternative dispute redressal mechanism veers away from litigation, yet cannot be completely excluded from the same, and hence discussing the points of judicial intervention becomes rather a necessity, which the author has finally put through. So I'm humbled to have your comments on the book, Justice Sikri. It's an honor. In fact, I was discussing this with my family, and it's a certificate in itself to have your words printed on my book. I believe that these books will be better appreciated by the audiences. And with this, I would recommend all the practitioners, people from academics, students to grab copies of this book if they want to develop expertise in arbitration law and to understand how the process has been overhauled, how the act has been overhauled over the years. With this, I would like to thank everyone again for being part of this event. And I leave the stage for Prabhat.
Thank you, Saurabh. First of all, I would like to thank Honorable Justice Sikri, Mr. Stephen Lim, and Mr. Stephen Pinzo for taking out their precious time for this event. I would also like to thank and extend my profound gratitude to Mr. Sumit Malik, Mr. Raghunandan Malik, and Nilofer, and the team at EBC for their continued support and for conducting this event. As Mr. Malik had pointed out, this was my first book and my first association with EBC. Initially, I was quite worried as to how we will see the light of the book, and after the manuscript is there, what all we have to do, because this was my first publishing work as a book in a format of a book. So, but as rightly pointed out by Saurabh, I mean, the team at EBC, especially Nilofer, they were available at all points in time, and they were handheld us, and in no time we had the published book in our hands. So I really like to thank EBC for their continued support. Now, I would be failing in my duty if I don't thank my seniors in the profession for their constant guidance, friends and family, and without their support, this Herculean task would not have been possible. And I'm extremely humbled and grateful that my work is being acknowledged and encouraged by Honorable Justice Sikri and eminent members in the field of international arbitration, Mr. Stephen Lim and Mr. Stephen Pinzo. So about the book, being an arbitration practitioner in tribunals as well as in courts, I realized that of late in last 2 to 3 years, there have been spurt of Supreme Court and commercial high court judgments, significantly evolving the arbitration law, especially post the amendment of 2015, 19, and now 21. And sometimes in a lot of the important judgments, especially the Supreme Court judgments, they appeared contradictory and difficult to reconcile. I used to get a lot of constant queries. And there was also a lot of confusion and emphasis in public debate between what the law ought to be and what it is. As is famously said by Scottish philosopher David Hume in his Is and Ought problem theory, there is a distinction between what is and what ought to be, which is derived from what is. So arbitration jurisprudence in India, according to me, faced the same problem, wherein some courts leaned in the favor of what is and other benches pronounced judgments endeavoring to achieve the normative or the what ought to be goal. So the idea of the book stemmed from this problem and experience, so to speak. And me and Saurabh, during the period of lockdown, we started working on this. And our endeavor has been to synthesize the law of arbitration and to encapsulate with clarity in a concise manner the current position in law, so as to separate the chaff from the grain and to state with clarity as to what is the position of law as on date. The book covers each and every Supreme Court judgment, right from the commencement of the Act in 1996 to August 2021, when was the last manuscript was submitted, in a section-wise commentary. It covers the important judgments of major high courts, Delhi, Bombay, Calcutta, and Madras, along with each and every judgment of the Supreme Court. I hope this small effort helps the practitioners as well as the honorable judges to quickly swift through the law. I would again like to heartfully thank the most esteemed panelists for taking out the time to engage with us on this important topic. Thank you.
Thanks a lot, Prabhat and Saurabh. Next, I would like to call upon Saurabh to begin with the panel discussion. is towards.
Thank you, Nilofer. So, the topic for the panel discussion today is amendments in the Arbitration Act which transformed India. Now, as a student of arbitration and as a practitioner of arbitration, there has been a lot of transformation in the Arbitration Act, right from the 1940s to the 1960s, 2015, 2019, and 2021. What we are going to discuss today in this panel in this esteemed panel, is how this transformation has been there in India. So with this, as Justice Sikri is there, my first question definitely goes to Justice Sikri, who has been writing a lot of judgments as well on arbitration when he was in Supreme Court. That's it. How are the amendments to the Arbitration Act being interpreted by the judiciary?
Thank you, Saurabh, for this question. Before I come straight to the question, let me make few preliminary or introductory comments. That is about the hybrid nature of the arbitration system. As I said earlier, while introducing your books, that it's a system which is driven by party autonomy. The two parties, they choose the private, the arbitrators, or from the, in the sense not from the court, but they want outside the court system should be there. And they, whatever mechanism, in whatever way it is on, the parties have not only exercised their right of party autonomy, but they have have faith in that system also. The person who's, or the arbitral tribunal which is going to decide, will bring about a fair resolution. At the same time, it is a hybrid system in the sense that court's assistance is required. Many times it is even at the threshold, while for the constitution of arbitral tribunal under certain circumstances. Sometimes even during the conduct of arbitration proceedings, when you need the help of the court in, say, summoning of the witnesses, etc., where we have the provision under the Act. And of course, after the award is given, for the enforcement of that award. And the challenge to that award is also the function which is to be decided by the court, whether award meets the muster of Section 34, under which it can be challenged, and whether grounds are made out, or if the award is challenged, then this has to be decided by the court. So in that sense, it is a hybrid system. But having said so, what is important is that the court's function is limited to aid the arbitration. It is therefore, when we say in a layman language, when the award is pronounced and it is challenged in the court, courts are not sitting as appellate courts over the judgment of the. So why I have said so? This delineates, or this demarcates very clearly what the courts are supposed to do in an arbitration. And it is the courts, of course, law is passed. Amendments we are talking about amendments. Amendments are there. Why these amendments were necessitated? I'm referring to that. But then the legislature has passed the law. This law was passed on the basis of, as we said, UNCITRAL model law. Now, on the basis, UNCITRAL model law is adopted by, I think now it's almost close to 200 countries who have enacted that law. That is in now same law in UK also, Singapore also, and many other countries, almost similar laws with, tweaking of some of the provisions, but are almost same. But why, in spite of same law, it has operated differently in different countries? Why, particularly if I may talk about Singapore, is able to create and generate that feeling, which to some extent UK also, or to great extent UK also, but I'm giving only as an example Singapore, why it is able to create this kind of feeling that the arbitration culture in Singapore is conducive to the stakeholders. It is not only conduct of arbitration, but enforcement thereof. And it is because of the reason that the courts in Singapore have been able to demonstrate by their judgments while enforcing the law that we are arbitration friendly. The courts are here to support the arbitration. So therefore, when it comes to the role of the judiciary, this has to be the hallmark. And why I made these comments, even when it was same law, which was in India, or I'll say almost the same law or similar law, we had to carry out these amendments frequently over the year. So first amendments come in 2015. This was, if I may say so, and we'll come to those because your question is how amendments interpreted by the judiciary. So these amendments, if I would say that the 2015 amendments were introduced by the legislature on the recommendation of the Law Commission after experiencing the manner in which the Law of Arbitration of 1996 Act was interpreted in certain judgments. So therefore it was, if I may say, and because I don't say that is the even word used by one of the, in one of the judgments also mentioning about Bharatiya International, that the muddied water, this is the very strong expression which is used, had to be clear. And so few judgments which were given, and out of those two which are prominently cited are ONGC, SAW pipes, and Bharatiya International. So they, in a way, the feeling was that, look, they are not in tune with what is the ethos and what is the spirit behind this 1996. That is one. And number two, there were certain other, may not be because of the judgment, but because of the provisions, either the manner in which they were interpreted or in the language or the statutory language which was used, there were some problems. So first, I would say that the aim or the purpose behind 2015 judgment was to cure those so-called defects which had appeared, either because of judicial pronouncement or because of the provisions per se which were there. So you keep that in mind, and my answer to this would be, when we come to this, that by and large, after 2015 amendment, the courts have now gone ahead and they have now captured the spirit behind this. The law, as I mentioned, and if I may, for paucity of time, we will not be able to say much because there are many judgments which have been pronounced on various amendments which were carried out in the 2015 Act. And therefore, the first thing which I am saying is that now it is, message has come in last 7-8 years, or maybe now 10 years, the judgment, and therefore it started even before 2015 judgment, the 15 amendment, that the courts are now supporting. So the amendment which was in section 2.2, whereby this certain sections such as 9, 27, 37, they would apply to international commercial arbitration, a very significant judgment. Other was in respect of section 34. So first judgment was to take care of Bharatiya International, first amendment. Second amendment was to take care of this ONGC SAW pipe, which can be said that, and it is again Supreme Court has said in one of the judgments that by section 34 ONGC SAW pipe stands legislatively repealed or overruled. Although ONGC in any case in sale judgment, Bharatiya International was overruled in that sale case, Constitution Bench judgment. And other thing which was again important was about section amendment in section 36 about the automatic stay, etc. That it will not be, because that was a problem which was found in the section. There was no, the way it was interpreted was correctly interpreted, but it was a problem in the section. But having said that, let me tell you, sometimes we, because it is a interpretative method by which you sometimes are able to way through it. As a High Court judge, way back in 2005 or 6, I had said that the 36 should not be automatic and stay of the, and therefore courts have the inherent power to impose the conditions. Of course, this view was not accepted because it was said that no, the plain language of Section 36 says, which says that there would be an automatic stay. So that was taken care of. And it is all now, if you see in past Wind Solution Private Limited, also the Supreme Court, and that is a judgment where the Supreme Court had said that Bhatia had muddied the waters by holding that Section 9 would apply to arbitrations which take place outside India, etc. And that is what is provided. And another very important thing was that recognizing from this, when it comes to this, in this very judgment, the court said that, taking into consideration the provisions of Section 2(1)(f), that what is to be seen is that it is the party, the difference between party-centric and place-centric. So these are what I would say are some of the judgments which have been given, and coupled with Section 34 judgments. If you see, I need not say so much. I mean, now the law is very clear. Supreme Court has very clearly said, High Courts are also taking that view. There are hardly now any cases where the court would be interfering with the arbitral awards. And the manner in which public policy of India was defined after the amendment, although I am personally of the opinion that even without the amendment, that should have been the approach. But in any case, if amendment was necessitated and amendment has been carried out, so after the amendment, this has been now taken care of. And another amendment in 2015 of Section 17, where equating or giving the same powers to the arbitral tribunal, which are given to the court under Section 9 for passing interim measures. This was also a significant amendment. And what is the effect of that, which the courts have now interpreted? That the moment arbitral tribunal is constituted, we'll stay our hands off. Then Section 9, we will not entertain. Even if it is filed, we will thereafter stop proceeding, and we will relegate the parties to the arbitral tribunal. And you know that in many cases, the courts have passed the order. This Section 9, which is pending before us, would be placed before the arbitral tribunal. It will be treated as application under Section 17, and this court will, the arbitral tribunal can pass the order, because this could become possible only when powers of the arbitral tribunal under Section 17 are brought at par with the powers of the court under Section 9. Otherwise, earlier parties would be saying that, look, how we can go to the arbitral tribunal? Arbitral tribunal has lesser power to grant interim measure, which was the position before the amendment. So these are some of the amendments of 2015 and how they have been interpreted. About 2019, I'll only make one observation here, and because that is not a question of interpretation of judiciary, etc. But what I would say, whereas 2015, my remarks was that it was to cure many defects which had arisen, but when it comes to 2019, the amendments with ACI, etc., and other things, and institutional arbitration which are introduced, it is a step in furtherance of making India as an arbitration-friendly country, and or making it attempt to make it. It has not been fructified so far. Attempt to make it an international arbitration hub as well. So this would be my, in short, my speech.
Thank you, sir, for giving this thought-provoking response. And I think it's good to understand that how courts have been interpreting the amendments in the Arbitration Act. With this, I would like to proceed to my next question to Mr. Stephen Lim. So, Stephen, you have been practicing in and out of India, and you have been doing a lot of arbitrations you have been an arbitrator where Indian parties are involved. How do you perceive the amendments made to the Indian Arbitration Act from a lawyer who has practiced in Singapore?
Thank you, Saurabh, for that question. Let me begin my answer with a little bit of a personal anecdote. My association with arbitration in India goes back more than 10 years, to about 2011, when I first started getting involved in the arbitration working community in India. And across that time, I've had many conversations with Indian practitioners and others about the various amendments to the Arbitration Act. And I think there was a general consensus that actually it was more a question of mindset that needed to be adjusted. And it wasn't the act itself, because ultimately the act itself was the model law. And we've seen the model law work quite well in many other jurisdictions. So it was a question of mindset. And I think that's a rite of passage for any jurisdiction which is introducing the model law for the first time, where the legal profession and the judiciary hasn't yet had the benefit of the experience of dealing with the model law. And I can say that the very same thing happened in Singapore when we introduced the model law. We have had amendments to the International Arbitration Act in Singapore because the judiciary got some very basic principles about how the model law operated incorrectly. One of the first decisions was a decision where a judge found that by adopting the ICC rules, the parties had intended to displace the International Arbitration Act, leaving then the arbitration to be governed by the Arbitration Act, which was a different regime from the model law. It's a fundamental error, and it just stemmed from a lack of appreciation of how the model law operated. And as with India, we had introduced quickly legislation to amend that, which is why you have Section 15A of the Singapore International Arbitration Act to make it clear that by merely choosing a set of international arbitration rules, you are not intending to displace the International Arbitration Act, which brings into force in Singapore the model law. So it is a rite of passage. It takes getting used to and understanding, and it takes a long time, I think, to really understand them. I mean, those who have had the benefit of practicing international arbitration in jurisdictions before us, I think have had the benefit of learning of the experience of those who have had experience with this. But those of us who didn't, needed to take some time to get on top of it. I've been practicing in international arbitration for, I would say, close to 20 plus years now. And it's taken quite a while for me as well for a few things to click. It's taken years for me, finally, after reading Gary Bond's book for several times, it finally clicks why he says some of the things about how the model law operates and how the New York Convention operates. It takes some time to really get yourself familiarized fully with how it operates. I mean, as another personal anecdote, I would say that I had the privilege, actually, of practicing with Sundaresh Menon, who was the Chief Justice in Singapore, in the early part of my career. And I think the both of us did our first international arbitrations around 1998. It was an ICC arbitration seated in Paris. And if you look back now at the discussions that we had about arbitration practice in that time, it was very rudimentary, even though Sundaresh Menon is now recognized as one of the leading lights of arbitration. I mean, no one is born an international arbitration practitioner. You have to learn it. There's a tremendous amount to learn. It's very rewarding to learn it because it's a fascinating area, but you have to learn it. And I see the various amendments that you've gone through in India as part of that learning process. It's a process that Singapore walked through as well. And I having seen how the changes have taken place over the last 10 years, I'd say that India has definitely been progressing in the right direction. And I think I'll tell you later on another personal anecdote about how I had to deal with this issue. But I can say that with great confidence that I have great confidence that international arbitration will be practiced as it is practiced in other leading international arbitration centers now. And this comes from the fact of me working in arbitrations involving Indian parties seated in Singapore and elsewhere, but also seated in India, I've now sat in a number of arbitration seats in India, and I can say with great confidence that these international arbitrations are conducted in a way which is no different from how I would have had conducted it in Singapore or England or anywhere else. And it is a passage of learning, but I have great confidence that, through the various amendments you've had, through guiding that mindset, what really it was all about, it was guiding that mindset. You have now created a fully realized understanding of how international arbitration operates. And since we have been commending the work of young arbitration practitioners, a younger arbitration practitioner, I have to say that I also have great confidence in the next generation of international arbitration practitioners coming out of India. They have tremendous experience and exposure. Many of them have practiced in the best arbitration practices all over the world. And I have no doubt that we will continue to see Indian arbitration continue to develop to greater heights.
Well, thank you, Stephen. And it's important to note that for India, it's been a learning cycle, and we have appreciated the amendments in such a way. With this, I'll go to Mr. Pinzo, and thank you, Mr. Pinzo, for being here. And I have a very specific question to you. You must have been following the jurisprudence or the judgments which are coming out of the Indian Supreme Court recently. And in India, recently the court has recognized the concept of emergency arbitrators. How is this judgment, do you think, going to affect the standing of India in the entire world in the arbitration index, if there is any? And where do you see India when these kind of judgments come from the court?
Sure. Let me start by saying, again, it's an honor and privilege to be here, and congratulations to both of you on the books. And it's a privilege to follow Justice Sikri and Stephen Lim as they've made comments. And maybe to answer the question about emergency, the Amazon decision and the approach to emergency arbitration, let me echo a little bit of what you've heard already. I think from a foreign perspective, the issues that we pay attention to when we think about India as a jurisdiction have been this interplay between the courts and arbitration, the length of the process, and the various amendments that Justice Sikri has singled out, and Stephen's point about mindset have been what's been so notable about the development really in the last decade and really in the last 7 years. And it's been driven by the court, the Supreme Court, it's been driven by the legislature, but it's also been driven by this thriving community of people who have embraced and really understand arbitration. And that takes time. And if you would ask me, what does India need to do next? It is to breathe a little bit, let this development now settle in, don't constantly tinker. But the fact that both the Supreme Court and the legislature has been so fast to deal with problems that have emerged. So we see this with the way the question of how long arbitration should take. There was a problem that was solved in a too draconian way with time limits, and then the legislature responded by saying let's moderate that, and that happened so quickly. This interplay between domestic and foreign arbitration, of course, has always been of particular concern to people interested in international arbitration, and over the last decade, that has been clarified both by the court and by legislation. And then when we move to the things that still trip up arbitration in India, as the courts are coming to understand their role and to embrace arbitration, I think things like interim measures have been, and it will be, one of the things that still need clarity. And by reputation, at least, interim measures still becomes more of an uncertain thing in Indian practice. So with the Supreme Court recognizing not just emergency arbitration, but emergency arbitration from foreign seated arbitration, we're making two huge leaps. One is that we're reinforcing again the general idea that interim measures are important, and interim measures can come from arbitrators or even from someone appointed before the tribunal is appointed. And while it's tacit recognition in that context, it says that India is at the front cutting edge of international arbitration practice by recognizing that concept, and then by going further and being one of the few jurisdictions that's wrestled with what do we do with a foreign emergency arbitrator award or order, and saying it's enforceable. It does say this is a jurisdiction that not only gets it, but gets the most sophisticated problems and is willing to be on the leading edge, which is such a transformation from where it was 10 years ago. And that's not a criticism, that's just a fact. It takes time, as Stephen just said, and as Justice Sikri said, and as you trace in the book, for these ideas to grow and for, most importantly, the courts and the lower courts to understand that. So I think the emergency arbitration decision is an example of the education and the mindset change that Stephen mentioned in action. And I think that's where you stand back as a foreign lawyer and say, we can have some faith and trust that this is a system that gets it and will continue to get it. And now we're fine tuning rather than making fundamental changes. And so that's my reaction, both in terms of this question of where does India stand in the index of seats. If there's such a thing, I think it will take time, in part because it's perception and in part because it's a massive system with lots of courts, and you need to make sure that development sort of infiltrates and that growth and that knowledge of what arbitration means and that what the correct interplay between the courts and arbitration is, and what the correct and how to deal with foreign seated arbitrations. But I think this is just it's a flag to say this is a jurisdiction that is moving fast to be a leading jurisdiction, and we'll get there soon enough. So that's my specific answer on the impact of that decision. I don't, if the question is, do we need then to see an amendment to the act to recognize emergency arbitration? I leave that to the Indian lawyers. I in some ways, that will again reflect the idea that the legislature and practitioners are aware of how to fine tune the act to make it sort of best in class. But also, I kind of like, as a common law jurisdiction, to say, okay, the Supreme Court has made it clear. Let's trust that it will now be followed. So I don't know that it's as important today as it was a few years ago to make sure every development is enacted in legislation. But I leave that to practitioners on the ground.
Thank you, Steve. Well, I understand that we are on the right track. And thank you for appreciating the decision by the Indian Supreme Court. And to answer you, as I understand that we would not need an amendment, as I see it, because the courts have interpreted that it can be read into the act. So that being the case, as of now, I do not personally perceive any amendment being brought to the act. Considering that, for last 6 years, we have had a couple of amendments in the act. With this, I would like to move to Prabhat, who is the co-author in one of my books. Prabhat, as you have been practicing on arbitration law and you have gone through all the amendments, can you please let us know how 2021 amendments are going to portray India on the international forum?
Thank you, Saurabh. So it's a very pertinent question, and because right now 2021 amendment is the latest amendment and not much of a judicial precedent has been laid out on this amendment or the effect of this amendment. So before answering question, I'd like just extend and add to what Mr. Stephen Finozio was saying, that it's actually the one common trait of investors, as I perceive it, across the globe, is that they look for robust institutional mechanism and certainty in law. Now, 2015 amendment was a tectonic shift in the Arbitration Act, and it had to take strides ahead and in matching with the international standards. Now, post that 2019 and in fact 2021 amendment, it is changing very fast. And if India aspires to be a global arbitration hub, it all depends on how robust institutional mechanism we put in place, as well as certainty in law that we provide. Now, coming to a question regarding the 2021 amendment, in relation to approach to arbitration law, India is always, in my perception, there has always been 2 steps forward and 1 step backward. So now, in light of 2021 amendment, I would say that we have taken a step backward, where initially the overcautious approach under the Arbitration Act 1940, where the imprimatur of the court was a prerequisite to the enforcement of an arbitral award, that was done away with by the 1996 Act. In fact, in conferring direct enforceability upon arbitral awards, 96 Act went a step further than the UNCITRAL model, which allowed an award debtor to resist the award both at the challenge stage as well as at the enforcement stage and recognition stage. Now, at the outset, it's evident that 2021 amendment undermines this trajectory. For example, I just go into a little bit technical aspect. Prior to the 2015 amendment, the enforcement provision under Section 36 of the Indian Act provided that the filing of a set-aside application under Section 34, it automatically stayed the enforcement of an arbitral award until the set-aside application was finally decided. In practice, this led to dilatory tactics, encouraging the losing party to challenge awards in a bid to delay enforcement. Now, 2015 amendment sought to remedy this. The Section 36 was completely replaced in its entirety, and the new Section 36 provided that the filing of setting aside application does not automatically stay the enforcement of an arbitral award. Instead, a party was now required to make a separate application seeking a stay of the enforcement, and the court had the discretion to determine whether to allow that application or not. Now, the regime of automatic stay after mere filing of setting aside application was given a go-by in this 2021 Amendment Act, where a new proviso has been added, where that if the court is satisfied on a prima facie basis that the arbitration agreement or the contract, which is the basis of the award, or the making of the award was induced by fraud or corruption, then unconditionally the award shall be stayed. Now, this mandatory language used in the provision that shall stay the award unconditionally on prima facie satisfaction, this will incentivize the losing party to make vague allegations of fraud and to see what sticks. And the provision now does not give the courts the discretion of staying the award on conditions deemed fit, if it finds that there is prima facie fraud or corruption. In the standards of fraud and corruption are also vague, considering they have not been defined in the Act. So it remains to be seen how the courts will apply the new proviso in cases of fraud and corruption. However, according to me, there are two sources of uncertainty. That is, firstly, it is unclear what the prima facie test will entail. Now, fraud and corruption allegations often involve complex questions of fact and are difficult to prove, usually requiring detailed arguments and evidence. Now, if the courts apply a test that simply accepts the allegations of fraud or corruption, this could incentivize the parties to make assertions, bold assertions, in a bid to derail the enforcement. Secondly, the discretion that was provided to the courts, this degree of judicial discretion in cases of fraud and corruption would be limited. Now, there are two ways to look at it. One is, if fraud or corruption is prima facie established, it simply removes this discretion. The other would be the new proviso simply imposing conditions on a stay where a prima facie case of fraud or corruption is established. The courts still retain the general discretion to determine whether a stay should be granted in light of all the circumstances of the case. Now, as Mr. Stephen Lim pointed out, that it depends more on the mindset of the courts and the judges. So, according to me, the latter interpretation is more plausible, considering the judicial stand post 2015 Amendment Act, which furthers the intent of the Arbitration Act. Now, however, the uncertainty injected by the amendment remains, and it creates more issues than it solves, which may once again need clarification. The second aspect that I would like to point out is, now this 2021 amendment, by introducing this proviso, it provides a second round of, in effect, in practical terms, second round of challenge. Now, in Section 34(2)(a)(2), I suppose, there is an arbitration agreement can be set, an award may be set aside if the arbitration agreement is invalid in law on account of fraud or corruption. Now, under the amendment Section 36, this enforcement may be unconditionally stayed even if the contract was introduced by fraud or corruption. And secondly, again, in explanation 1 to Section 34(2)(b) of the 96 Act, where it talks about public policy of India, it says that the award may be set aside only if the making of the award was induced by fraud or affected by fraud or corruption. Now, even at the enforcement stage now, under Section 36, the court would have to look at the merits of the matter to find out whether fraud or corruption was a factor in relation to entering of the contract as well as making of the award. So now, according to me, in practical terms, this will basically result into two stages of challenge of award as opposed to one, thereby creating further hurdles in enforcement of award. Now, this 2021 amendment I feel that it expresses a fundamental distrust in the arbitral process. And considering India's ranking in terms of enforcement of contract and integrity of contracts, out of the 193 countries, we rank at 163. So I think this amendment is a step backward, as opposed to the 2015 amendment, which had a tectonic shift towards a pro-arbitration regime.
Well, thank you, Prabhat, for giving your views on the 2021 amendment, and I hope you have captured these in your book. and you will market this across
Yes.
to everyone. And thanks a lot for this. Coming to Justice Sikri, sir, I have one more question in my mind, that when we look at the amendments to the Act, are we looking at a trade-off or balance between the traditional mode of litigation and arbitration, which India wants to see in future?
It's a very interesting question, and I think part of it I have already answered. But before that, I come to this. I just would like to make very few remarks on what Stephen Pinzo said and what Prabhat have said.
Certainly.
Because they have some bearing on the answer which I'm going to give. Insofar as Amazon judgment is concerned, in fact, it was in my mind when I wanted to speak up on the first question which you asked, but slipped out of my mind. Because this is, in a way, a very, very progressive judgment because of one reason, which is this, that if you remember, Law Commission had specifically recommended that there should be an amendment in the definition of award also to include emergency award. In spite of that recommendation, the legislature did not do so. So it was a case of causus omissus, where recommendation is made, legislature doesn't do so, but it is now introduced by judicial pronouncement. So that is what it signifies. Of course, somebody can say that, look, it amounts to adventurism. It amounts to what legislature did not accept. It has been, in a way, legislatively done. Judicially done. It's a judicial legislation, etc. But I don't see in that way. What I find is that, look, going by the spirit of the Act, and where today emergency arbitration, which is a part of arbitration process, an initial part, where even when the tribunal has not been constituted, so Section 17 doesn't come into picture, and Section 9 has its own pitfalls, delays, etc. And emergency arbitration in that sense becomes very, very important. So the court thought that no, this should be read into it in this. So this is, in a way, a progressive judgment in that sense, which sends a very good signal to the international community. And in this context, let me now say what Prabhat has said about 2021 amendment. Of course, I entirely agree with him that this is a regressive amendment, where it is nullifying the effect of 2015 amendment to Section 36, which I also pointed out at that time. And but having said so, what I feel is, and why I chose the example of Amazon first and then this, that the way, and what Stephen Lim also said, in last 10 years, 8 to 10 years, Indian Supreme Court or our high courts also have shown a progressive attitude, and they have shown an attitude which should be in support of arbitration and not to scuttle the arbitration process. And therefore that includes the enforcement of the arbitral awards as well. The way Section 36 now, when it comes to challenging the award, the way the courts have taken the approach, and they are hardly now interfering. I'm even in the absence of, in this context, I say, even in the absence of any definition of corruption or fraud, but we know that these two terms are very well-known terms. These two terms are judicially defined so many times. We have in our mind the concept of what corruption is and what fraud is. And I'm hopeful that the mindset which Stephen said, yes, these amendments were made to bring that mindset, which it has brought the desired results, would continue, and the threshold of charge, the allegations of corruption or fraud would be very, very high, even while taking a prima facie view. Of course, he is right, Prabhat is right, that it may give now another chance those who want to challenge the award. They will say or want an automatic stay. They may, because this ingenuity is there. in those persons who want to challenge for some reason or the other, that may introduce such grounds. But that doesn't mean that the court will also be carried away merely because it is done. And why I'm saying so, if you remember, there is in Booz Allen, Supreme Court said that if it is a case of fraud, it is not arbitrable. But then Supreme Court later on clarified, and I take it as a pride that I rendered that judgment, that not merely because there is an allegation of fraud, it becomes non-arbitrable. So non-arbitrable. So we have defined in that, and which has been now taken further in subsequent judgments also of Justice Sanjeev Khanna's judgment. I've forgotten the name of that case. But so therefore, I am hopeful that the same thing would continue here as well. That is one thing where I say, and in this context now I answer your question specifically to that. Of course, as I said, I have almost given that answer in any case, and I have hope that mindset is changed of the judiciary. It will still go into that direction, notwithstanding amendment in 2021. We don't know, although I agree, as I said with Prabhat, that such an amendment was not even needed. But maybe they thought that in a case where it is a matter of fraud, and maybe another reason, if I may frankly and bluntly say so, that maybe so many public sector undertakings, I'm not naming, who are now, having so many awards against them. And the magnitude of the amount, etc., which is involved is also, which are pending in the courts. Maybe government or legislature thought that, okay, let us, because, or it may be a genuine feeling that in many cases the fraud is perpetuated, and because of this awards are given and all. But yeah, he is right that it doesn't augur well. It doesn't, insofar as arbitration board is concerned, or the integrity of the arbitrators is concerned, such kind of message. But yeah, please now tell me, I'm sorry, in the process, I have exact question.
No, sir. So, no, it's good to have your views on this, sir. My question to you was, do you think that these amendments are going to pave the way to, to take off the burden from the courts?
Yeah, yeah, that is what I said, that I've almost answered. If you see, we in Indian system, as far as judicial system is concerned, much time is taken in Section 11 applications because of ad hoc arbitrations in India, where still we have more arbitration which are ad hoc, and Section 11 applications are filed, and where the court has to come. That these amendments first now, when Section 11 is interpreted now, and they say that we will only look into two things: whether there is an arbitration agreement, and the dispute has arisen. That's all. All other things would go, and that is how it is interpreted. So therefore, it is. As far as when earlier the courts were not intentionally, but sometime driven because of these circumstances which are raised in the petition, to go into the other issues as well, it is not necessary. So burden is off in that sense, the moment merits comes. So these two things, and when Section 11 comes, so therefore it can be decided. And I have seen, as a matter of practice, and you too would be knowing, that many times on a second hearing after notice, sometime on the very first hearing, the courts are able to dispose of the application and appoint the arbitrator. So that time is. Then likewise, Section 34, after these amendments, when I remember after ONGC saw pipe had come, and the way it was interpreted, courts had become the appellate court. It had, per force, the court had to undertake the exercise, whether the award, because even one ground that the award is given is contrary to the contractual provisions. It becomes a matter of public policy, and it has to be gone into. Now it has become contrary to provisions. Everybody had a right. Look, this is the provision. This is what the award says. So in a way, going into the merits as if it is an appeal, and which were, of course, I still say, in spite of ONGC saw pipe, even at that time, maybe more than 95% awards were upheld. But the time which was taken was too large, because the court had to just sit, and I have done those exercises because this was the judgment of Supreme Court, which was binding on us sitting in the High Court. And therefore, we had to undertake that exercise in going and giving judgments in hundreds of pages, ultimately saying that the award is proper. But it would consume so much time. That is not happening now. So that is another very, very significant aspect of these amendments. Of course, as far as Section 36 is concerned, as now we know, and we have already discussed a lot about it. And because of these reasons, I feel that of course, work would remain. Section 11 applications would still come. Award would still be challenged. But the time which would be required, having regard to these amendments in disposing of this, is, shortened significantly.
Thank you, sir. I certainly understand that, these amendments are definitely going to take off the burden from the courts, because they will definitely seek to ease out the time. Mr. Lim, my next question is to you. When you look at the Indian arbitration scenario, which is the one single judgment which you can point out which changed the future of India?
I think without a doubt, the answer to that question has to be the Balco decision, which is dealt with extensively in the commentary that you've produced. And I can tell you, and the reason for that is that is the case where the Indian Supreme Court embraced not just the letter of the model law, but also the spirit of the model law. That's when that mindset finally changed and clicked. And from then on, it's been a road down for the Indian Supreme Court of further mastering how the model law works, but more than that, how international arbitration works. And we ended up, as Steve has spoken about, and Prabhat and Justice Sikri, of the Amazon case, which I think is a very forward-thinking decision, because we're still having a discussion as to whether interim relief is an award under the New York Convention or not. And I'm one of those who thinks that it should be, and I'm glad to see that the Indian Supreme Court has gone down that road. But I told you earlier, I'll tell you a personal anecdote about my brush of Balco, and I'll tell you that story now. In 2012, I was appointed as an emergency arbitrator by the SIEC. It was one of their early emergency arbitrations. I was told about the 9th or the 10th emergency arbitration case that the SIEC had taken on. It was a case involving German and Indian parties for a construction project in India. And the claim, the emergency arbitrator application, was to injunct the call on a performance bond issued by an Indian bank. The German party was a claimant, and they thought at that time they had one hurdle that they needed to cross, which was that at that time it was thought that under the tests for interim relief, you had to show that the harm you would suffer would be irreparable in the sense that it couldn't be reversed or compensated by a monetary award. So they had a problem, they thought, because since this was a performance bond, it's all about money. And if indeed it turns out later that they didn't get the injunction, I mean, could they be compensated? Well, it's just a question of being compensated in terms of money. So in order to get around that, they came up with this argument that India would not enforce a subsequent award in their favor, ordering that they be compensated for the drawdown on that performance bond. And they cited to me the Saw Pipes case. They cited to me the Baier International case. This is before Balco. And of course, as I was mulling this, I didn't want to commit myself on paper in an award to say that India would not enforce an international arbitration award. Although at that time I was confronted with the Saw Pipes case, and I was confronted with the Baier International case. Fortunately, I found a way around it by finding that that irreparable harm didn't need to be such a high standard. And in the context of the facts before me, it was more of a balance of harm rather than having to prove irreparable harm. So I got myself out of that sticky wicket, with that finessing the criteria, but I heaved a sigh of relief that I went down that road, because shortly after that, the Balco decision came down from the Indian Supreme Court. Now, what I've looked like an idiot for putting myself down on paper to say that India would not enforce an international arbitration award. So that is my personal anecdote, and why I will always remember the Balco case, and why the Balco case is to me a very significant case.
Thank you, Stephen. It was insightful to know, how you dealt with the situation pre-Balco and how eventually Balco laid down the law, which you have actually laid down, maybe in that case. But thanks for that insight. With that, I'll move to Mr. Pinzo. And Mr. Pinzo, my question to you is that what, from a practitioner of arbitration law, you think is still missing from the Indian legal landscape when it comes to arbitration?
Well, from a practitioner's perspective, as I said earlier, I would like some peace and calm and to have things settle down a little bit. The gaps, I don't think there are major things missing. And I think actually the Amazon decision shows that it's all there in the current law. From a practitioner's perspective, what I do think of, and again, this is a foreign practitioner's perspective, but informed by many conversations with Indian lawyers, I do think there's still time for there to be evolution about who sits as arbitrators and to open that community up. And I think that has knock-on effects that are important. So both that's a mindset issue again, who will we appoint as arbitrators in Indian cases? Will it go beyond the current approach, which tends still to be retired judges and justices? Will we move to a broader community? In that regard, the idea of regulating who can be an arbitrator worries me from a foreign perspective. I was very happy to see that the 8th chapter came out, but where that goes in terms of regulation is a concern. I do think, although I've softened on this view, that growth of institutional arbitration still solves practical problems. So I think seeing the growth of institutional arbitration will also help India as an international center. So these sorts of developments, which are less fundamental and more about how practice works. And of course, one of the great successes, I think, and we've talked a lot about it, so I don't want to echo it, but one of the great successes of the recent amendments has been the removal of the automatic stay. So anything that allows creative litigators to go back in. And so when Prabhat says that's a concern, that worries me. And I've written on the issue of fraud and corruption and whether that can be exploited. So all those things that interfere with the smooth running. But otherwise, as I said earlier, the greatest answer for me is time and a chance to breathe. But I do think the next generations need to be broader. So if you want arbitration, that mindset to continue to broaden opportunities for the younger lawyers to be arbitrators, to expand that, and perhaps to do that through some more institutional arbitration. To me, as a foreign lawyer, are ways to help cement, continue, and develop all these issues we've been talking about. And I know that's a short answer, but hopefully that's a helpful answer.
No, that was a perfect answer, Steve. I understand that we need to breathe, and I'll take that personally as well when it comes to writing books, that I need to breathe. Thank you. Thanks a lot. Prabhat, I come to you with my next question. And my next question is that when you look at the 2015 amendment, it created a lot of uncertainty when it comes to its applicability. So what is your take on that? Why was that uncertainty?
Prabhat, you're on mute.
I'm sorry. Yeah. So the uncertainty, this uncertainty wouldn't have been there. This is prior to the amendment. I'll just give a background. Prior to the amendment of 2015, the Law Commission of India, in its 246th report, it recommended introducing a section 85A, which provided that the proposed amendments were prospective in nature and were to apply only to fresh arbitrations commenced after the date of the enforcement of the amendment, and fresh applications, that is proceedings filed before the court or a tribunal after the date of the enforcement amendment. Pending arbitrations and court proceedings filed prior to the enforcement date were to be governed by the unamended provisions. However, the legislature somehow, for unknown reason, did not accept this recommendation and instead enacted Section 26. Now, the Section 26 was peculiar in the fashion that the first part of it provided that the amending act shall not apply to arbitral proceedings commenced before the date of the commencement of the amending act, whereas the second part provided that the amending act shall apply in relation to the arbitral proceedings commenced on or after the date of the amendment act. Now, Section 26 was in the nature of a savings clause and a provision which sets out the extent to which the rights accrued and liabilities incurred under the repealed provision were to be governed by the amending act or the repealed act. Now, the plain reading of that suggested that while it saves all arbitrations commenced before the date of the amending act, the applicability of the amending act to fresh applications or pending court proceedings in relation to arbitrations commenced before the amending act was not clear. Now, this led to a lot of litigation where the broadest view, with several conflicting judgments of the various high courts, where the broadest view taken by one of the courts was that it allowed application of amended provisions to fresh applications relating to arbitrations commenced before the amending act, pending court proceedings, as well as fresh arbitrations. On the other hand, the narrowest view was of one of the high courts in which they made the amended provisions applicable only to fresh arbitrations and applications relating to such arbitrations post the date of the amending act. Now, the Supreme Court judgment in BCCI versus Kochi finally settled this issue, and it clearly held that court proceedings initiated after coming into force of the amending act will be governed by the amended act, even if they relate to arbitrations that were commenced prior to the amended act. Now, the fulcrum of the court's decision was the distinction it drew between the terms of arbitration proceeding and in relation to arbitration proceeding. The court held that the arbitration proceeding term refers to the actual proceedings before a tribunal, while the term in relation to arbitration proceedings, it relates to all the aspects of the arbitration except the arbitration proceeding itself. On the basis of this distinction, the court interpreted the rest of the section to conclude that the date of the commencement of arbitration proceeding is irrelevant to proceedings in relation to arbitration proceedings. Now, the court at that point and time itself, the 2019 amendment press note was released by the government. So the court heavily critiqued the proposed amendments on the ground that the amendments, if approved, would result in the nullification of the 2015 amendment, not applying to a very substantial chunk of arbitrations which can benefit from the progressive law that had come about by the 2015 amendment. The court went so far as, in fact, directing that its judgment be forwarded to the law ministry and for a more thorough consideration on these matters. However, for some strange reason, it was not adopted. And however, I would like to point this out, that there are still creases to be ironed out, where though the judgment was laudatory for furthering the pro-arbitration approach, the interpretation was a little problematic considering there was a prior Supreme Court judgment of Thyssen versus Steel Authority of India in 1999, where the court held that the term in relation to arbitration proceeding was of wide amplitude and it included the term within its ambit, the arbitration proceedings also. Now, the legislature may have been in attempting to correct this, but instead did more harm by going directly against the recommendation of the Supreme Court in BCCI versus Kochi and literally negated the judgment with its 2019 amendment, wide Section 87. Now, this was again struck down by the Supreme Court in Hindustan Construction Company versus Union of India, and thankfully so, for being manifestly arbitrary and unconstitutional as it defeated the very object of the 96 Act. Now, this has been very captured in detail in page 415 of the commentary on arbitration law. So that's why I'm thoroughly aware of the proceedings of how it went about.
Thank you, Prabhat, for capturing it, that it has been captured in the book. And I think people will definitely secure a copy of your book to read about these very aspects. And I just go to Justice Sikri for one last question. Sir, both Stevens, they have been talking about how institutional arbitration is going to be the next thing. So how do you think that these amendments have brought institutional arbitration at the fore?
You see, as I said in my introductory remarks also, the purpose of the amendments, as I said, that 2015 amendment was there to take care of some ills or some to clean the muddied water, etc., which was there because of wrong interpretation of the some provisions or some absence of clarity in respect of some provisions. Whereas 2019 amendment, as I mentioned earlier, was a step in furtherance of making India an arbitration-friendly country. And here, the main thrust of 2019 amendment is to encourage institutional arbitration. Whereas if you compare countries like UK, many other countries of Europe and Singapore in particular, maybe if I'm not wrong, Stephen would tell maybe 80-90% cases, or maybe almost 100% cases where the arbitration is governed institutionally. Whereas in India, even today, I think 50 to 60% cases are still ad hoc. So this is because of the reason that there is a clause in the arbitration agreement that they have not said that in the event some dispute arises, we'll go to particular arbitral institution. So that may be the reason. But 2019 amendment, where the legislature made it clear that, look, we want institutional arbitration, we should encourage institutional arbitration. And therefore, for this purpose, even amendment to section 11, where the court can also, even in the absence of this, when the court is appointing an arbitrator or constituting an arbitral tribunal under section 17, the court can say, look, it would be under the aegis of such and such institution or such and such institution. That is one. Secondly, in 2019 amendment, this creation of ACI, Arbitration Council of India. This was a step at that time taken that, look, when the institutions, arbitral institutions, also that the arbitral institutions which come up, they are of repute and they gain that kind of popularity and public trust as well, and the trust of the stakeholders. So there have to be a grading, there will be a grading of these institutions. But unfortunately, even when this amendment was of 2019, till date, ACI has not been established or constituted, and therefore that has not come into play. So therefore, what I feel is that legislative intent is clear that we should encourage institutional arbitration. It's only that when it comes to the parties, of course, here also I would say that trend is changing. The percentage of arbitration governed by institution, which was very, very less few years ago, that is now increasing. There are many. Of course, I have seen many contracts in India, and particularly when one is Indian party and one is outside party. And here I'm talking Indian plus outside party, in the sense that suppose there is a contract with some public sector undertaking with an undertaking or with a company which is Indian company, but which has collaboration, or it's a consortium of Indian company and a foreign company. So there, even these public sector undertakings are agreeing we can have institutional arbitration and are accepting SIAC or ICC. I have seen, I am myself doing these arbitration as arbitrator in such cases. So therefore, this is increasing. But what I would say, that in order to create India as international hub, when India is a party or an Indian party is there in a dispute, and the other party is, say, from Germany or from England or somewhere else. So these two parties, they say, okay, we have to go to a neutral place and let us go to Singapore in the event of disputes, SIAC. This kind of culture, and this has not happened so far when it comes to India. That if there are two different other parties, even maybe within Asia, that they will say, okay, let us go to India. This is because so far we have not been able to create the institutions of that repute. I would again, at the end, I would end up by saying and giving an example, because I'm always amazed, and I really, not that I am now international judge of Singapore International Commercial Court, but my love for Singapore because of the reason what they have done and what they have achieved. This trinity, I always say, as far as international disputes are concerned, resolving the disputes, SIAC, if you want arbitration, SICC if you want court, Singapore International Commercial Court, and SIMC if you want mediation. So when we talk of ADR, of course, I mean, we also in India, we have Commercial Court Act and we have commercial courts, no doubt. So they have also created commercial courts. But this is the way India has become famous insofar as health tourism is concerned. Singapore has achieved that milestone or achieved that distinction when it comes to legal tourism. People are looking forward to Singapore. So that I hope, and so therefore, what kind, we have to just do this kind of thinking has to come, and there has to be deliberation on this, what we say in our, I mean, if Hindi, if I use that expression, Sagar Manthan, which is required, that deliberation which is required on this is that what we lack and what we have to do in order to create this kind of hub, which Singapore has been able to do in the last 15 years. So I ended that.
Well, thank you, sir, for your insightful comments. With this, we would wrap up the panel discussion. And I would, before I give the stage to Nilofer, I would like to thank Justice Sikri, Mr. Lim, Mr. Pinzo, and Prabhat, Mr. Malik and Nilofer for organizing this event. And I'm truly humbled that with your blessings, my books are launched today.
Again, congratulations for your book, both
Thank
of
you.
you.
Thank you. Thank you.
Saurabh and Prabhat. Thank you. Thank you, everybody.
This was quite a discussion. We hope our audience were enlightened and entertained by listening to this discussion. As we are running late, I would like to quickly wrap up this event with a short vote of thanks. We would like to thank Justice Sikri for releasing the books and agreeing to be the chief guest, Mr. Stephen Lim and Mr. Stephen Pinzo for agreeing to be the panelists, authors Saurabh Bindal and Prabhat for trusting us with publishing the book, to the EBC team, the legal editors, copy editors, DTP professionals, the citation team, and last and not the least, Mr. Sumit Malik for his constant support and mentorship and for having our back. With this, I would like to declare the end of this event. Thank you everyone for attending.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you.